Hello everyone, I'm George from Ireland. So this video is about criminal law in the law of England and Wales. So you've got to decide what a crime is. Well, obviously it's a breach of the criminal law rather than a breach of civil law, and I've extrapolated about the distinction between criminal and civil law herein before, not in this current video, but on the channel. So a breach of the criminal law includes some forbidden conduct. That's the external element of a crime, as well as the mental element of the same crime. So that's something internal in your mind. So the particulars of the crime can vary hugely. For instance, pickpocketing somebody's wallet would be a crime, or breaking into a computer system, shooting somebody's cat, or stabbing a person to death. These are all crimes. Now, the mental element, what went through your mind whilst you're carrying out this action, could be intentional. So that was your wish to commit this crime, or it could be reckless. I didn't intend to kill the person. I intended to hurt the person slightly, but it actually ended up killing the person. Or there could be willfulness and knowledge to these crimes. So when you're assessing a potential crime, you must always ask yourselves two key questions in this sequence. Number one, has the defendant performed a forbidden action? And number two, was that action accompanied by a state of mind which was also criminous? So I'll go over that again. A forbidden action and then a criminal state of mind, as in stabbing someone is generally not allowed. But then the state of mind, what if it was an injection given with the patient's consent by a doctor? Well, in which case there was no criminal state of mind, and so on. So we've got to have the forbidden conduct and the mental element. And if we've got both, then there's criminal liability, though there are a few exceptions to that. So remember the maxim, actus non fecit reum, nisi mens sit rea, as in the action doesn't make you guilty unless you have a guilty mind as well. So that then you are culpable. So you've always got to see whether there is some forfended action and whether the mental element satisfies the definition of a crime. So you also have a guilty mind. Actus reus, the guilty act; mens rea, the guilty mind. So we'll go on to this. So or Wilson, the jurist, said that murder is unlawful killing with malice aforethought. So malice aforethought is thinking wickedly in advance. You actually intended to kill someone or were reckless to the possibility of killing somebody. You do something which you knew was going to cause them a serious injury. You didn't actually wish to kill them, but the fact that you wished it to be a serious injury and is sufficient to make it murder if the person actually ends up dying. It's no defense to say, well, I didn't want to kill her. I just wanted to hurt her very badly indeed. Well, that very badly indeed carried over into actually killing her. You're still guilty of murder. So so that's what the malice is, the wickedry in your mind and a forethought in advance. So anyway, let's look at the situation. If a defendant has killed a human being, that could well be murder. Or if you killed someone but only intended to cause serious injury to someone, is that murder? Yes, it is. But now, what if this person killed another and had a valid defense? So this woman killed this man and intended to kill this man. Seems like murder. But what if this woman turns out to be a police officer who was shooting dead a knife man who just stabbed someone to death and was threatening to kill another, and then that knife man had refused to lay down his weapon, in which case the police officer was right to shoot him to death lest he poignard somebody else. So let's look at the three basic elements required for that to be the crime. The actus reus, as in the guilty act. So that is something that the criminal law forbids. So there are things such as driving without due care and attention, which is a crime, even though it doesn't have a necessary result. If you're driving without due care and attention, but you don't actually harm anyone or injure any property, that's still a crime. But now most crimes are result crimes. You stab someone which resulted in death, so that was murder. Or you stab someone which resulted in injury, so that was grievously bodily harm or something like that. Or look at the crime of rape, that is having sexual intercourse with someone without that person's say-so. So this is how it's said that the actus reus of a crime involves behavior with or without a particular outcome, which includes circumstances necessary for that behavior to be a crime. We'll look at the mens rea, that's the guilty mind. So in order to be convicted of a serious crime, we must prove that what the defendant did was culpable. So this is the moral principle which undergirds the criminal law, because we should only punish people who deserve punishment. Okay, there's also the principle of retribution. You should be got back by the state. You should suffer because of the suffering you visited on other people. Now, there are children who do things, they don't know what they're doing, they cause harm to each other, but they're not called to account for it. They've not reached the age of reason, which, by the way, is not defined. Anyway, things which we take into account in terms of the state of mind is, was there an intention to commit a crime, or there was recklessness about the possibility to cause a crime? You didn't actually intend it, you knew it was a significant possibility, but you proceeded anyway, in which case you're reckless. And if harm results, well, then you're criminally liable. Was there any dishonesty involved? Might not be outright lying, could still be dishonesty if it's less than an actual lie. Was there relevant knowledge leading you to know that this was a crime, that you knew was stolen property you were handling? Or was there some sort of belief or whatever of that this was a crime? Anyway, so these are called states of mind. So if you had a conscious attitude that what you're doing, if you were cognizant of what you're doing, then you could well be held criminally liable. So breaking the law, knowing you're breaking the law, is particularly reprehensible. Although, as it says, that ignorantia lexis non excusat. I hope I got my Latin right. Ignorance of the law is no excuse under law. So those who have breached the criminal law in such a manner, they merit condign punishment. Anyway, so why do we have these punishments? Well, it's possibly to deter people from committing crimes. You see what you get. It's protection of the public. You can't commit that many crimes when you're in prison. Things like that. Rehabilitation to turn bad people into good people and so on. So what Jeremy Bentham said when he invented utilitarianism is that punishments can't be deserved because they harm two people, not just one, unless the needs of society require it. Because the criminal has harmed somebody else, we don't want to harm the criminal too, though we're just increasing the suffering in the world. But if we don't do that, then there'd be even more suffering in the world. So utilitarians wish to reduce the incidence of antisocial behavior and people imperiling others. So it's also got a preventive purpose, the criminal law and these punishments, which I set out. So there are certain stigmatic crimes. Let's say sexual abuse of minors is regarded as uniquely reprehensible. And crimes of violence are very much detested these days. Curiously, you go back to the 18th century, certainly in England and Wales, it was crimes against property that were severely penalised, whereas crimes of violence, so long as you didn't actually kill the person, were punished rather more leniently. So anyway, there is no unanimity when it comes to the law of attempts, of people trying to commit a crime but not actually succeeding, because they might not have actually harmed anybody. Anyway, so we ought to try and have punishments to have a dissuasive effect on those who would have the commission of a crime in their contemplation. Say, I'm thinking of robbing a bank, but I better not, because I don't want to spend 20 years banged up in the slammer. So there are some fault elements, and there's some no-fault elements. There's strict liability crimes. So that you are held responsible for, even if you didn't know you were doing them. I didn't realise breaking the speed limit. Well, it doesn't matter if you don't realise. It doesn't matter, you don't have the mens rea. The actus reus was committed, therefore you're still convicted. So you might not be cognizant of what you're doing. Gross negligence manslaughter is another example of this. That's killing a human being not intending to do so, but you're still at fault. So that's not as bad as murder. And it's not as bad as voluntary homicide, but we'll come on to that in more depth later. So there are various defences here, so and which might forfend a person being found to have criminal liability. So the actus reus and the mens rea might be there, but there are some defences which will operate, such as self-defence, mental illness, consent, sometimes necessity or duress. So these offences involve a certain moral claim which could have you acquitted. First of all, it'd be wrong to punish the defendant because although they did something immoral and illegal, they had no capacity or opportunity to obey the law. H.L.A. Hart, the celebrated legal scholar, he put it this way in Punishment and Responsibility, 1968. Duress, I was forced to do it. I would have been killed if I hadn't smuggled the drugs. That defence might operate. Someone called Call Grant has tried this in his appeal, but that didn't work. Or indeed insanity. I was mentally ill. I didn't know what I was doing. And if psychiatrists will vouch for you, that defence might work. There is another approach you can take there because of extraordinary circumstances. There are some justifications. Well, I had to kill him because he was threatening to kill me. There's also automatism, where it's said that the person in effect loses control of his or her own body. Anyway, so then there are curious situations where even if there's an actus reus, the curious thing about rape is the act in itself, intercourse, is not illegal so long as the person is of age. So this man, let's call him Adam, he's having intercourse with Belinda, right? So and she's of legal age, right? So that would be legal. But then look at the mens rea, the state of mind. He believes that she's not consenting. Now that would make it rape, where in fact she actually is consenting, in which case it's not rape. So strangely, so some actions, the actus, the action can be lawful itself, but it's the state of mind which would make it illegal. All right. So anyway, we'll look at the burden of proof here. So remember, it behoves the prosecution to prove someone's guilty. The prosecution are those who are arguing that the defendant is guilty. Imagine that somebody shoots someone else dead. And on the street, and loads of people see. So the defendant is charged with murder, and she says, yes, indeed, well, I did kill the person, but I did it by mistake. So that's about her mens rea, the state of her mind. So now she did not wish to kill anyone or to cause grievous bodily harm. Maybe she just wanted to give somebody a fright. So she could be acquitted of murder on that basis. She might still be convicted of homicide. There was a Ruth Ellis case, 1954, the last woman to be executed in the United Kingdom, where Miss Ellis, she murdered her abusive boyfriend, and then she was charged with murder. She's put on the witness stand, and her defense barrister cross-examined her, and he asked her, "What did you intend when you pulled the trigger?" And she said, "To kill him." With those three words, she talked her way onto the gallows. So her intention was to kill. If she'd said, "I only intended to give him a fright, I was trying to miss," if that had convinced the jury, she would have been found not guilty. She would have got off for murder. She might have been convicted for homicide because you did still something dangerous. You still killed somebody. So accidentally killing a human being through criminal conduct, as in firing guns and firing a gun in a crowded street, you could still be found guilty of homicide. You might have got off with murder. But anyway, because she confessed of her own free will under oath that she willfully killed her boyfriend, then she was found guilty of murder and she was indeed hanged. So that was not a wise question of a defense barrister to ask. Now, you say, why didn't the defense barrister coach her? I'm going to ask you this question. You say to kill him. No, don't say that. Saying I was just trying to scare him. I wasn't aiming to miss. But barristers, they're not allowed to coach witnesses. It's deeply unethical. They could be struck off if they're caught doing that. Well, there's another notable case, Wilmington and the Department for Public Prosecutions in 1935. This went to an appellate court. So the House of Lords, they had to think whether the actus reus was enough. And therefore, it was up to the defendant, when they're running a homicide defense, to prove that it was an accident. And they said, no, that's not true. The burden of proof does not pass to the defendant in such a case. As in, you shoot somebody dead and you claim it was an accident rather than deliberate. It's up to the prosecution to prove what they are alleging, that indeed it was willful. So remember, there's this crucial assumption of innocence until proven otherwise. So in all elements of the offence, that the burden of proof is on the prosecution. It's up to them to prove what they are asserting. Having said that, that's not quite true, because some defences are just so fanciful that the burden passes the other way. So the actus reus, as in the action you actually carried out, the prosecution are the ones who actually have to do the proving. Let's look at this. For example, rape is a crime. So that's having sexual intercourse, whether oral, vaginal, or anal, with a person without that person say so. The prosecution has to convince the jury that the sexual intercourse took place, because he might say no, it didn't, and she might say yes, it did. But even if they prove that it did take place, was it without the consent of the person alleging rape? So they must prove both elements. Intercourse occurred, and indeed it was non-consensual. So let's look at a mens rea. Supposing a purse is stolen, for instance, the prosecution has to show that the defendant took the victim's purse and had no wish to ever return it, or there's handling stolen goods. I didn't steal the thing, but the person gave it to me, and I knew it was stolen, and I sold it on or something. Even though I didn't sell it on, I still handled it. I still passed it on to somebody else. That would still be a crime. So you have to prove that the defendant knew he was handling stolen goods. Suspicion wouldn't be enough. So remember, the prosecution have to prove what's going on. The defendant doesn't have to prove to the contrary, because you can't always prove a negative. But there are some, you has to be some sort of vaguely credible defense. I shot him dead because I thought he was an alien from the planet Zark or something. In this case, it's so ludicrous that I don't think the prosecution will be required to prove that he didn't believe this person from the planet Zark. So the evidentiary burden which is borne by the defense is not unduly onerous, but the purpose here is to avoid the court being burdened with ridiculous claims to rebut. It would be a waste of the court's time. It would be offensive to the court's dignity. So this is consonant with the notion that a person is innocent until proven guilty. That's the prosecution's standard. The prosecution has to prove beyond all reasonable doubt. There can be an unreasonable doubt left in a person's mind. Even the most villainous person in the world might leave a modicum of doubt in the mind of a juror. Is he really guilty? Is this really all true? Because we can seldom be absolutely certain. There might still be a penumbra of doubt. So that is just a little bit about criminal law. I hope you found that lesson of a little bit of utility. So please contact me. I tutor people in law, history, politics, religious studies, citizenship, geography, French, English language, English literature, English as a foreign language, religious studies, all sorts of subjects. So look me up on YouTube. Well, you're on YouTube. My other channels, George from Ireland, on Facebook, on Instagram, and so forth. Toodaloo.